Okay, let's go ahead and call the meeting to order. We're running a few minutes behind schedule, and hopefully we'll get back on track. Representative Everson, are you ready? Okay. Call. Let's have a little order, please. Call House Bill 92. See if that's the one.
Yes.
That's it.
Thank you, Mr. Chairman, ladies and gentlemen of the Judiciary and Non-Civil Committee. I bring before you House Bill 92, which is a bill that passed out of this committee unanimously last year and did not make it out of rules. Since that time, I have been speaking with the Medical Association of Georgia, addressing their concerns, and I think now we have a bill that is appeasable to all parties involved. Basically, what House Bill 92 does is it changes the provision that makes it a misdemeanor to tattoo within 1 inch of the eye socket to provide that it is a misdemeanor to tattoo either or the two folds of skin and muscles that can be closed over the exposed portion of the eyeball. And that is the current language that is before you in House Bill 92. Basically, all it does is it allows the permanent cosmetic technician to perform cosmetic surgery or micropigmentation at the eyebrow level only, and it does not go any further than that. And they are in agreement with that, and Medical Association of Georgia, they are in agreement with that language as well.
This bill has been here in, came through subcommittee and full committee last year, and has been in subcommittee and was on for full committee earlier this session. Is that correct?
That's correct, Mr. Chairman.
Okay. All right. I'm going to see if I've got the correct mic here. Is that Chairman Cooper or Representative Randall?
Okay, it's me. Okay. Representative Everson, how does we passed a bill last session that had to do with this, if I'm correct?
We passed it out of this committee, but it didn't make it on the floor of the House.
Didn't something, may I ask, didn't something pass that had to do with restricting and go to governor for a signature, Mag?
Not concerning this legislation.
Okay. I'm sorry. So I thought they did something that had to do with this.
No.
I was going to ask you how it differed. I stand corrected. Sorry.
Okay. Is that Representative Byrd or Representative Collins?
Representative Collins just stepped out.
Okay. Still flashing down there. No further questions from. Okay. I'll have to come back to him. Any further questions from the committee? Further questions from the committee? Maybe he'll be back for the discussion on the motion. Vice Chairman Mumford.
I'd like to thank the member from Snellville for bringing this legislation, and I'd move a do pass.
Chairman Cooper, second it. Is that right? Okay. All right, we have a motion that House Bill 92 be given a do pass recommendation. Is there discussion on the motion? Is there discussion? Hearing none, all in favor of the motion, please indicate by raising your right hands. All opposed. The motion has been adopted.
Thank you, Mr.
Representative Everson, we will report that to the Rules Committee favorably. You want to go ahead and take up your other bill while you're there?
I sure will. Thank you so much once again.
Another bill that's also been before this committee.
Yes.
Correct?
Yes, it sure
Okay.
has, and we have received various input from various parties interested in this legislation. Make sure we're working off of the same sheet here, LC 293316S, substitute to House Bill 924. After being heard in the committee, we went back and worked with different parties in regards to this legislation, and we made some changes, and I want to briefly cover those changes. Beginning on page 1, line 9, We changed the name of the act to the Billy Folk Seatbelt Act. Also, we changed the portion of the driver improvement class to be only mandatory on the second offense. After the second offense, the person does not have to undergo an improvement class. And in addition to that, on line 15 of page 1, we changed the age, the time frame from 15 years to 20 down to 15 years to 18. So once a teenager becomes 18, this will not apply to that teenager. And most of you, well, all of you have heard the testimony at the last committee hearing in regards to House Bill 924, brought on behalf of the large numbers of teenagers that are being killed while driving automobiles across the roads of the state of Georgia. And statistics have proven that over 50% of those teenagers, their lives could have been saved if they would have had their seatbelts on. So this bill is an attempt to send a message to our teenagers from 15 to 18 years of age that we expect you to buckle up. As the legislation is currently written, on the first offense, the teenager will receive a $25 fine. On the second offense, that fine will increase to $50 plus a 3-month suspension of license, in addition to taking a driver improvement course. And on the third offense, that license will be pulled for 6 months. And on the fourth offense, that license will be pulled for 12 months. And that's, in essence, Mr. Chairman, the bill. And I'll be happy to attempt to answer any questions. I do have DDS here who are in support of this, as well as the Insurance Commissioner for the state of Georgia, John Oxendine, as well as It Won't Happen to Me organization, Bill Richardson, I believe, who's sitting behind me, amongst others that are in support of this legislation.
Is the insurance commissioner here? I would have recognized him had I seen him.
No, he's not here.
Oh, okay. He's here by representative. Okay. We would have been very honored to have him with us today. Thank you. At the last meeting a week or so ago, when we took this bill up, Representative Everson, 2 or 3 members had some significant concerns. I know Representative Lunsford was one of them, and I'm glad he's here today. Have you dealt with his concerns?
Yes, he and I have spoken in regards to that, and we're on the same page.
Is that?
I guess we're on
I won't
the same
ask
page.
you to comment. Your microphone's not on, and I won't turn it on if you don't want me to. All right. All right. Vice Chairman Mumford.
I was reading the summary that had been prepared. I don't know who had prepared it, but it did raise a sort of a question because I really don't see it here in the bill. In your summary, it seems to be indicating that if you, well, I guess it says after the suspension period, payment of a restoration fee and completion of driver services, approved driver improvement program, after the second offense, the suspension will terminate. You're not providing for an early termination of the suspension upon completion of the driver improvement program.
No.
Is failure to do the driver improvement program mean that you're suspended forever under that section?
I wouldn't think so.
So you don't know?
DDS? Yes.
You're suspended forever?
Until you take it.
Does anybody know what the cost of that particular program would be? Is that a regular, well, is that that's a regular driver improvement course, I think is what they're called? Do they cost vary across the state? you know what an average cost is? No idea. Never heard of what anybody paid for one of them? You must have never had your license suspended. I understand.
Is that one of those that we may be able to now to do online?
I think that remains to be seen.
So there is still hope that maybe we won't be doing them online?
That remains to be seen.
That's a good answer. Further questions from the committee? No. You raised a good lawyer. Representative Abdul Salam.
Thank you, Mr. Chairman. I was trying to scan the room with my blind eye. The gentleman that was here each time before from one of the driving schools that actually had Billy Folks as one of his students, can't remember his name. Is he here? Because he could tell us what the cost is. That's what. And I can't see. Yeah. And nobody knows what that costs. About $75 for the 6 hours total. I thought it was less than 100, Mr. Chairman. One of the things that we did discuss and I thought agreed upon in each conversation about the educational component was that this would be something different and in addition to your regular driver improvement. It would not be the same course of study or the same program that the students take before they get their license. It's got to be focused on the safety aspect.
Mr. Chairman, if I may respond to that, in accordance to DDS, this is not the same class that you take prior to receiving your driver's permit.
That's
this is
good.
something totally different.
Thank you.
Does that take care?
Yes, sir.
All right. Representative Levitas.
Just having a motion at the appropriate time. Mr.
Okay.
Chairman.
Vice Chairman Mumford.
I'd like to make sure, I may be directing this to the Department of Driver Services. Your bill provides for a reinstatement fee of $50 if by mail and $60 in person. Is that correct?
Yes.
All right. And
No.
you've checked with DDS and that's
check
going to
with
work?
Yes.
Okay. So it's not going to be $225?
No. And that language was drafted on the language that's currently in law now in regards to drivers who drive off without paying for fuel.
Okay.
They suspend their license.
And just to follow up, my understanding is that there somehow or another this particular section is being exempted from all other fees.
Exactly.
Okay.
It does not have
So
points associated
on a
with
second
it.
offense, you're looking at about $175 theoretically to get your license back after the 3-month suspension.
Yes.
90-day suspension. All right. Thank you.
Further questions from the committee? Further questions? Further questions? Chair recognizes Representative Levitas.
Mr. Chairman, I make a motion, move to pass the committee sub.
We have a move and a second that House Bill 924 be given a due pass recommendation. Is there discussion on the motion? Is there discussion? Hearing none, all in favor of the motion, please indicate by raising your right hands. All opposed? Thank you, Representative Everson. You've had a
Thank
good
you.
day today.
Oh, I don't have another one on there?
You get to join the great unwashed back over here now. Representative Sims, glad to have you with us today. House Bill 1071.
Thank you, Mr. Chairman, members of the committee. I've been over in Ways and Means. I apologize. We've only got 19 income tax bills today, and I've been nearly asleep. I'm trying to get back over here into this great
We're
committee.
pretty good at waking folks up
Gotcha.
over here.
That's what I want. I want to be woke up. You got one over there. You better hurry. You got about 6 more to go. 4 years, I think. Mr. Chairman, I'm sorry. Okay, I'm sorry. I didn't want to interrupt. Mr. Chairman, I'm bringing you House Bill 1071 today. This is a bill that was asked for by my magistrate. What has happened? What happened, and the reason for bringing the bill during the movement of a prisoner from the county jail over to the courthouse. There are no guns in the courthouse. The guy was carrying the guard was carrying a taser, and in the meantime, when that during the transfer, this inmate grabbed the taser and attempted to try to tase the guard. When it came to pass that they were trying to find out if there would be when they brought charges against the inmate, it was found that the word taser was not in the law under Code Section Title 16, Chapter 10. And all I'm attempting to do is add the word taser as a felony offense. So they did bring a charge of battery against the individual, but they could not use the felony charge. Had this individual been successful, it could have been a bad day for the guard and for others that may have been involved. That's the reason for bringing the bill. I'll stand for questions.
What were they trying to charge him with initially?
A felony for removing, trying to take a weapon or protective device away from the guard. At the time that he was not carrying a pistol, our guards don't carry pistols over to move the folks from the jail over to the courthouse, and they do that as protection.
They didn't think they could charge him with aggravated assault?
They may have done that. I think they wanted to use this. They wanted to go under this because of taser, and they were a little afraid that it may not. I don't know if the aggravated assault. I think they subdued the man before he actually did anything that could have actually injured the guard. But had he gotten a taser, that would have been, I think, detrimental to that guard.
Okay. Representative Collins.
Thank you, Representative Sims. We had talked about this Friday, and I apologize. This weekend I had drill, and so I hadn't got back to this. But we do have counsel here today, so I'm going to see if we can address this question. Jill, is there, because Representative Sims said the other day that earlier we had to add chemical spray. Now we add taser, and it seems like as the personal protection of equipment of these jail officers or sheriff's department dealing with this, could we make this? And that was the question we asked the other day, and he was fine with the author was fine with it. But we just needed to know: is there a way we can make lines 11 and 12 just inclusive, to where we can say any personal protective equipment carried by the officer would be covered under this act, or would there be an unintended consequence there that? I just didn't want to say the next latest and greatest security device used that we have to come back here, add it to the bill, and move forward. Could we just encapsulate that?
Seems like you could say the security. Well, I didn't quite catch your lingo, but the security device, including but not limited to, and then put in what we've got so far. And then if you had the including but not limited to, that would necessarily, as long as it's a personal security device.
Right. Well, and personal protection, we could do it either. I'm just curious in that sense of not having to come back to this, because it's always, being devices made that they can use. And just in a sense of simplifying it and making it easy understood and not using the inclusive language of it only having to be one of the listed ingredients.
Any response?
I have no any qualms against doing that. If that's the will of the committee, I'm all in favor of that.
Okay. Chairman Knox.
I wonder if the things that are identified in here, I believe, are items that are authorized for use by corrections officers and police officers as weapons. There are some things they can't carry. You can't carry a machete on you, and you can't carry a bolo or some stuff like that, which are can be used for defense, but they're not authorized for law enforcement or jailers to use. So I'm not sure how broad we want to make it, because it ought at least be limited to what would be an authorized weapon that would be permitted. You can use mace because the law says you can use mace, and because I guess there's been a general consensus by the law enforcement community that that's something that's not that can be used for the application would not be beyond what would be required in order to control the subject and so on. So I think that may be why these things are identified individually. A taser, for instance, is appropriate and permitted by most agencies now. I think tasers are, and we struggled with that for a while, whether that was okay or not. But I think certainly you could say language that would include, that would be more generic than this. I'm just not sure whether or not we could do it without having some problem about whether or not you can use something that isn't authorized under the law.
And I have no problem with that either, Mr. Chairman.
Further questions? Further questions from the committee? No one had signed up. Okay. Vice Chairman Mumford.
Move to pass.
Okay, we have a motion and a second that House Bill 1071 be given a due pass recommendation. Is there any discussion on the motion? Any discussion on the motion? Hearing none, all in favor indicate by raising your right hands. All opposed. Thank you very much, Representative Sim. You had a good day.
I'm going. Thank you. I appreciate it. Got to go back to Ways and Means. Thanks. Back to work. Yeah, I'll see you.
You ready on yours? You want to do it? Robbie, you want to do them both? Okay, Chair recognizes Vice Chairman Mumford on House Bills 1297 and 1298.
Mr. Chairman, ladies and gentlemen of the committee, taking up 1297 first. Excuse me, I got to find my copy of it. This is a bill that is being brought to attempt to satisfy some federal requirements for our laws relating to how we handle sex offense cases. The particular sections are attempting to deal with the rights of victims of sexual offenses and make sure that they have certain rights under our code as they currently have under federal law. Section 1 is a section that changes the existing law regarding sexual assault protocol in each judicial circuit. The new language requires that such protocol take in consideration the new provisions on forensic examinations which form the basis for this bill. I'm sure that many of you know that each judicial circuit is required to develop and maintain a sexual assault protocol. That has existed in our state for many years, and these are an effort to simply bring into our individual sexual assault protocols these protections for the victim. Section 2 changes the current statute on preservation of biological evidence. The new language provides that DNA evidence that might be obtained from a sexual assault must be preserved in the same way that DNA evidence is preserved in a prosecution under any of the 7 deadly sin statutes. It includes all sexual offenses for which a forensic examination might be performed, such as a sexual assault against persons in custody or under the care of a mental health professional. Section 3 sets out new provisions for forensic examination of victims of sexual assault It sets out definitions of terms in 17-5-70. It provides that DNA evidence collected in a forensic examination must be maintained, regardless of whether or not a report to law enforcement is made. It provides that the victim of a sexual assault has a right to a free forensic examination, regardless of whether he or she reports the offense to law enforcement. It provides that the investigating law enforcement agency shall be responsible for payment for the examination. It requires that that DNA be held in sexual assault cases that are prosecuted, if I understand this correctly, for 10 years, and for those in which no charge is filed for 12 months. Additionally, it provides that as a condition of prosecution for an offense that no person be required to take a polygraph examination. I do not know of any event in this state where such a thing has ever occurred, where somebody has said to a sexual assault victim that unless you can take and pass a polygraph, I am not going to prosecute your case. I assume that this is a requirement that must have developed because of some practice done elsewhere in the United States, and we are supposed to bring ourselves into compliance with it in order to ensure that we continue our funding for some of our battered women's shelters and things of that type. Ms. Centerfit is here. She has a very good understanding of this bill, as is Ms. Perry, who also has an understanding of it. I'll try and answer questions, and I may have some amendments to try and propose to try and perfect the bill.
Okay, let's see if we have questions. Representative Abdul Salam.
You want to come on up? Ms. Abdul Salam? Yes, ma'am.
Thank you, Mr. Chairman. Representative Mumford, just a question on Section 2, I believe it's line 11, talking about maintaining biological material.
Yes.
I'm just wondering, is that the 10 years, is that current law, and is that enough time, given the fact that we've had so many people cleared many years after the fact based on DNA testing?
That is something that's new. I don't know what the current, that is current? Oh, I'm sorry. Yeah, I'm told that, excuse me, I'm told that is current law.
Yeah. I guess I'm wondering about the wisdom of that when we've seen people in this very room that have been released after 20, 21, 23 years, whether the 10 years might not be a short time frame.
Well, it's been explained to me that there's a certain amount of expense and difficulty attached to this. I believe that the 10 years was sort of something that the Georgia Bureau of Investigation felt that they could continue to do. And that's probably about all I can tell you about that. Personally, I don't have a problem requiring its maintenance for a longer period of time, but this was a compromise to try and make this bill workable.
Thank you.
Further questions from the committee? Further questions from the committee? Representative Ramsey.
Chairman Mumford, I guess this is kind of a general question, but it's raised by an item on summary of HB 1297. If you could indulge me as the new guy here at the General Assembly, I've heard this on a number of bills that we have federal funding that's jeopardized if we don't pass the legislation to come into compliance. And I hear witnesses say that, and it's on our summary here. And did we get a letter and who did we get a letter from that set out what we needed to do to come? Not that I don't take people at their word, but I
that's just in the air.
Yeah, right.
And let me tell you this. First of all, Mr. Ramsey, I generally do not let the threat that we're going to lose X number of dollars of state funding propel me into any particular formulation. That's just my personal method of doing business. You know, I have been told that there are. That's not my purpose in bringing this bill. This bill really is fairly simple. It means that a woman who's claiming she's been sexually assaulted cannot be told that you've got to take a polygraph and pass it, because people take polygraphs and don't pass them for reasons that have nothing to do with whether they're telling the truth. So that sort of an intimidation tactic is something that this bill is trying to meet, and then trying to make sure that the cost of these examinations are covered by our law enforcement agencies is another goal that this is trying to meet, and then preserving these specimens for specific periods of time is the other part of this bill. So I would not urge you to support this bill because you're afraid you're going to lose funding. I would ask you to do it because you think those are good propositions.
No, I don't have a problem with the philosophical underpinnings of the bill. I hear that. I've heard that a number of times, and it's just more curiosity than anything.
You rarely hear it from me.
Thank you.
Thank you, Representative Ramsey. That was an excellent question. I asked that many years ago and didn't get an answer either. So, I've been waiting about 12 years to see a piece of paper and on that. Further questions from the committee? Not this bill, but others through the years. Further questions from the committee? What's the pleasure of the committee? Chairman Cooper?
Do pass. Second.
We have a motion that House Bill 1297 be given a do pass recommendation. Is there discussion on the motion? Is there discussion? Hearing none, all in favor of the motion, please indicate by raising your right hands. All opposed? That one will be reported favorably, Vice Chairman Mumford.
Thank you.
Can you stay to that time on the next one?
I can certainly try. I was surprised by the speed of that one. House Bill 1298 is a bill which would change the requirement to establish a plea of insanity or mental incompetence from a standard of beyond a reasonable doubt to a preponderance of the evidence. This is the standard that is evolving in cases of this type in the federal courts. There have been cases tried in Georgia where the district attorneys have already commenced using this standard. I bring this bill because I think that it has merit, because having dealt with a number of cases on both sides of the question of insanity and also retardation, these are things that are very difficult to prove. That to a a person's intelligence is something that can be argued over probably forever, and I just think that beyond a reasonable doubt is too high a standard to hold a mentally retarded person to, and I think that a preponderance of the evidence would be sufficient. That's probably about all I have to say on that.
Okay. We have some who have signed up to be heard on that. But before we do that, let's see if there's any questions from the committee on House Bill 1298. Questions from the committee? Questions from the committee? This group
you don't
had
have to solicit them, Chair.
This group had a very complacent and passive weekend here. All right, we have three. That's a good word too. 3 people who have signed up to speak on 1298. Brian Kammer. Did I pronounce your name correctly? Okay. Come around, Mr. Kammer. Please tell us who you're with.
Mr. Chair, could Mr. Cameron and I speak together? We talked about this.
Sure.
Thank you.
If he's agreeable to that.
That's fine.
and Mr. Jack Martin, Georgia Association of Criminal Defense Lawyers. Tell us who you're with, Mr. Kammer.
Mr. Chairman, I'm Brian Kammer with the Georgia Resource Center. I'm a staff attorney there. I've been there for about 12 years. We're a nonprofit law office providing representation to indigent death sentence prisoners in Georgia.
Okay, thank you.
Let me just give the committee a little bit of history about this. In 1988, actually, in this room right here, we passed the first bill in this country in which the death penalty, an exemption for anybody mentally retarded, was passed. Georgia was the leading state, the first state to pass that. And that was because then Attorney General Michael Bowers thought that was the right thing to do and pushed that legislation. At that time, Georgia, and it's still pretty much the same, 60 to 70% of Georgians favor the death penalty. By about the same amount, 60 to 70% of Georgians do not believe the death penalty is appropriate for someone who is retarded. And with the help of then Attorney General Michael Bowers, we passed this legislation. I have a little bit of a mea culpa about this because I was down here with Joe Drollet and we were drafting that final version of it. And what we did was in 17-7-131, we simply added a provision that if the defendant may be found guilty but mentally retarded, the jury or the court acting as trier of facts finds beyond reasonable doubt the defendant is guilty of the crime charged and is mentally retarded. If the jury or judge so finds, they must say it in their verdict. I read that to mean that you had to find the defendant guilty beyond reasonable doubt, not that you had to also find him retarded beyond reasonable doubt. That was my mistake because the Georgia Supreme Court interpreted that conjunction to apply to both of those things. And that has been the development of the Georgia law since then. What we did was we passed Section J, which says that if that finding has been made, then the person cannot be sentenced to death. The history in Georgia was the Georgia Supreme Court shortly thereafter in the Foster and the Fleming cases held that, well, because of the opinion polls showing the vast majority of Georgians against death penalty for mentally retarded because this legislature had passed that provision, will hold it unconstitutional under the Georgia Constitution. And at that point, then they started to revisit people who had already been sentenced to death who were arguably mentally retarded. And in those cases, they said all you had to do is prove it by a preponderance of the evidence. The law further developed into the Burgess case, another case I have to take responsibility for. I was involved in that case as well, in which the Georgia Supreme Court said, well, I know it looks wrong, but we're going to have one standard because the legislature says beyond reasonable doubt. We're going to have another standard under the Constitution, preponderance of the evidence. So you have two different standards in this one area. The next important development was the Atkins decision by the United States Supreme Court, which is a fairly recent decision, which Atkins versus Virginia, in which the United States Supreme Court held that, no, it is against the United States Constitution to execute the mentally retarded, but didn't go forward to say a burden of proof. Following Atkins, virtually every state has said the burden of proof should be a preponderance of the evidence, and for good reason, because anything that's scientific, like mental retardation, is awful hard to prove any scientific fact beyond a reasonable doubt. And here you're talking about something that a burden of proof by preponderance of evidence, more likely than not, is the standard proof for those types of things. So Georgia was originally the leader on this, and now we're at the back of the pack because now we're the only state that I know of that has a beyond a reasonable doubt standard. I'll tell you that the retardation associations are all in favor of this bill. The Department of Human Resources is in favor of this bill. And it is a good improvement in the law. And I'll say two other things. When the ABA did their finding about having a moratorium in Georgia for the death penalty, this is the most glaring problem they said in the Georgia death penalty, was this egregious standard for a mentally retarded person to have to prove their mental retardation in order to avoid the death penalty. One final thing, I know that the prosecutors, I've talked to them, have raised the concern about what about the possibility of a life without parole sentence in this situation? That can be easily corrected if it's the will of the committee by just simply adding to subsection J, which is 17-7-131, that a person who is found guilty of a crime but mentally retarded, that by preponderance of evidence, the death penalty should not be imposed, and the court shall sentence the defendant to imprisonment for life or life without parole. Already it's a 30-year minimum for any type of sentence for a murder conviction anyway, but if it makes the committee more comfortable to add that language, we have no problem with that. Often people who are mentally retarded, who have been involved in such a crime like this, do much better in the prison system. And I'll tell you, I've had experience with mentally retarded clients. In every situation, it's always they're there, and there's somebody else who's not mentally retarded there, and they get involved in this crime because they're led to the person who is not mentally retarded to be involved in the crime. Because mentally retarded people just do what people tell them to do. Those are just tried to give the committee a brief summary of the history. Brian's dealing with these cases all the time, and let him speak now.
Mr. Chairman, members of the committee, I have a few points I want to make about. I don't know if this is on. A few points I want to make about in support of the bill. The first is to point out that Georgia is the only jurisdiction in the country that imposes the reasonable doubt standard on defendants seeking to prove mental retardation. The vast majority of states impose a preponderance standard. A handful of states impose a clear and convincing standard, and in a couple of those states it's been overturned in favor of preponderance because the courts found that it was unconstitutionally burdensome. In other words, it was going to cause the system to sentence people to death who were more likely than not mentally retarded. And that is the problem with the reasonable doubt standard. It's the heaviest burden known to the law, and what it is going to tend to do is put people in the position, mentally retarded people in the position of being executed, even though they can prove they are more likely than not mentally retarded, even though they can prove they are clearly and convincingly mentally retarded. Oh, okay. And even as Justice Sears stated in a recent case in Georgia here, the Warren Hill case, stated that Georgia will execute people who are almost certainly mentally retarded under this standard of proof. And this issue is percolating through the federal courts right now in Georgia, and I believe that it is going to be declared unconstitutional in the next couple of years, few years. So I think that this change is coming. And I feel that it would be appropriate for Georgia to be ahead of the curve on that. In my work, I work extensively with mental health professionals who evaluate our clients, many of whom have symptoms of mental retardation. And what these mental health experts will tell you is it is impossible to make a mental health diagnosis beyond a reasonable doubt. The standard for mental health professionals is to a reasonable scientific certainty, and that is not as stringent a standard as beyond a reasonable doubt. Mental retardation is a syndrome that is a complex mental health diagnosis. It involves a lifelong condition. It involves proving that someone had the condition before they were 18 years old and can continue to have it at the present time. So it's a diagnosis that depends on lots of information and is a very can be often ambiguous proof. So it is very difficult, if not impossible, to meet the reasonable doubt standard. Those are the points I wanted to make today.
I did want to emphasize this doesn't mean anybody's getting out of jail. Still, the sentence is life imprisonment. It's guilty but mentally retarded. It's just prohibiting them from getting the death penalty. And I will say one final thing. I know a number of the district attorneys, Fred Bright, for example, and others, have already started to go to this standard because they are fearful if they don't go to this standard, and they get a death sentence, then that will be overturned ultimately on appeal because the preponderance standard is the view of all the courts now, and Georgia is now in a small minority. Quite frankly, this is supported by the people of Georgia, has been supported by the people of Georgia for years, supported by both parties. It is something that ought to be done, and it's a good improvement in the law and brings us up to speed with everybody else.
Thank you very much. Questions from the committee? That you? Okay. Chairman Cooper.
Right. Is there a standard number where they decide a person has to have an IQ under a certain?
The standard, the definition in the statute is the standard definition. It used to be the American Retardation Association. I think it's the American Association of Mental Defectives is what it's called now. But that's their standard. It's also the DSM-4 standard, which says it has to be an IQ of 70 or less. Okay. But since there's a standard deviation on most IQ tests, as you probably know, Representative Cooper, you could have as high as a 75 and still qualify because that might be a 70 or less.
Okay, one more question. I mean, I'd like to ask this to the chairman.
Yes.
I mean, since there was problems with the other law, do you think we need to specify in here that this does not mean that they cannot be given life imprisonment, or, as the gentleman stated, for clarification? Since
I don't know that would be necessary, and you may have an opportunity later in the session to do that in any event.
May I add to Mr. Martin's comments briefly in response to your question, Mr. Chairman? Is that okay? I wanted to add that the diagnosis is not just a score on a test of intellectual functioning. You also have to prove that the defendant has weaknesses in adaptive functioning, which in plain language means their ability to cope with daily life in the free world. And the problem that you often find in these cases is that people with mild mental retardation, people whose IQs land at approximately 70, they can do a lot of things that people who are not mentally retarded can do. They can drive a car. They can have a job. They can they can have a family. And so those are the kind of things that mask the syndrome and can persuade juries and judges and folks that these folks are not mentally retarded because of the standard of proof. I just wanted to point that out.
Very much, Representative Levitas.
Chairman, and I may have missed it, Mr. Martin, and I apologize if I did. What's the number of other states that have the preponderance standard?
I can't give, there's like 34, 35 states that have the death penalty, and the federal government has. I know the federal government's preponderance. Do you know that?
I think it's approximately in the 20s. It's like the states that have started to formalize their statutes that have done so, approximately 20, 25 states, the majority of the death penalty jurisdictions in the country, and have adopted preponderance.
What happened is when the Supreme Court in Atkins says it's unconstitutional, the general standard when you prove a constitutional violation is preponderance of the evidence, including like Miranda and other things. So that has been the assumption that that's the minimum standard of proof constitutionally on the United States Constitution.
Well, the anything below preponderance means less than proof, so obviously that would be the minimum. I guess my question is there a standard in between preponderance and clear and convincing?
No, not a recognized legal standard.
And here's my concern: is often, and this is not Representative Levitas talking. This is jurors that I've spoken with. Sometimes jurors who feel, boy, I'm not sure I want to do the death penalty. Here's a good compromise because I feel guilty that maybe there's an explanation. They may not understand exactly what they're doing and may come to it with not much more than a reason to want to not impose a death penalty, which I understand they're entitled to do. But I guess my concern is whether if we're doing a preponderance, whether we are setting the standard so low that we may wind up in cases where the death penalty, and you have to make the assumption for purposes of this argument that in some cases the death penalty is appropriate, that in those cases where it might be appropriate, because we've set the standard so low that people are going to be leaping at these findings. Now I know with the current standard maybe the bar is too high, I understand you to say, and that's why I'm wondering if there might be some middle ground.
Well, when I said preponderance is relatively low, I mean there's also probable cause, which is less. But you could have placed the burden on the state. So the burden remains on the defendant to convince the jury or the finder of fact. So it's not like we're the lowest. I mean, easily the burden could have been placed on the prosecution, and some states have thought about doing that. Or have a pre-trial hearing in which a judge makes a judicial finding, a little bit like a competency finding, pre-trial by a preponderance. Quite frankly, that would be my preference. But this is the.
I can't say that because it's a great shock to me.
But this this is the. We try to find out what's possible. And I think this is a good compromise. It places the burden on the defendant to prove by preponderance of evidence that the person is mentally retarded.
And I'm sorry, this is my last question, Mr. Chairman. What kind of evidence typically is proffered at this case, and what would be a kind of argument that you would make? And believe me, I've heard you make some incredible closing arguments here. What would be the kind of factors that you would say as a defense attorney in looking to this standard that you would argue as to why they should come up with this finding?
Well, you'd have to get a competent psychologist, an expert with good credentials to make a diagnosis of retardation. Absolutely essential. You have to have an IQ test, a WAIS-R typically. If it's a Spanish person, you have to use a Spanish WAIS-R. There are all sorts of tests to show an IQ of 70 or below. Then you have to prove adaptive behavior. There's certain tests for that, but what you most often show is problems with employment. I had a client who the only job he could hold down was making hats, and the only thing he could do in the hat factory was print the logo on the hat day after day.
And that's a good example. And the second part to this last question.
Report cards, those are actually usually the best source of information. You'll have teachers say he can't read. Fourth grade is when it usually shows up. He's not passing the subjects. Special ed teachers are great sources on this. And these are not easy claims to make.
And that's what I was going to ask you. What in the federal system or in other states, what is the amount of cases where the standard is preponderance of evidence that a finding of mental retardation is accepted by the jury?
Well, I'll take the opportunity to answer that
Please,
question.
I'm sorry. I meant this to either one of you. I apologize.
I don't know exactly the statistics in other states. I think since Atkins came out in 2002, the states are now starting to encounter these cases on a more systematic level, and yes, several defendants have been found mentally retarded either by a judge who deals with the issue pretrial, or and actually I think in a lot of the jurisdictions it is decided pretrial by a judge in a separate proceeding. I do not know how many other states employ a jury system or how many have been found to be mentally retarded by a preponderance of the evidence.
And that doesn't mean, of course, that it's the wrong conclusion. I'm not suggesting that. It may be that setting that standard and coming to that conclusion is right. But if, in fact, it was 75% of the jurisdictions start finding mental retardation on this standard, then that would suggest to me that maybe, not necessarily, but maybe that standard, they might be finding them in cases where it's not appropriate, where you don't have somebody like the hat factory example.
Well, let me offer this, that the preponderance standard is I would say is balanced by the difficulty of proving mental retardation. It's inherently difficult to prove because you have to prove that from childhood on that person has demonstrated cognitive impairments. So sometimes a child hasn't gotten the right testing or the records have been destroyed, and you can't prove that this person had an IQ of 70 or below when they were younger. You have to then get anecdotal information from family members or teachers or what have you. It's a huge effort to develop that evidence so that even just to get over the hump of preponderance, it demands a very, very high level of evidentiary development. And so I think that, and weigh that against the risk of executing someone who is more likely than not mentally retarded. I think the Supreme Court of the United States, in dealing with similar kinds of cases, for example, competence to stand trial, has said that risk is unacceptable. So I sort of think that your concern is met by the inherent difficulties of proving the condition.
Thank you, Mr. Chairman. Thank you.
Thank you, Representative Abdul Salam or Randall. Representative Randall.
Thank you, Mr. Chairman. At the proper time, I'd like to be recognized for a motion.
Okay. We have one other speaker. Any further questions of Mr. Martin or Mr. Kemmer? Thank you all for being with us.
Thank you.
Tommy Floyd.
Thank you, Mr. Chairman. Tommy Floyd for the District Attorneys. My main problem with this particular lowering of the standard is in the death penalty range, in the death penalty area. I'm not a psychologist or psychiatrist, but I've dealt with several death penalty cases where the claim of mental retardation has been made. And what I have found is usually you're talking about somebody with an IQ from 75 to 65. And to set the scenario, the court will send the defendant to the state once the claim has been made to the Department of Human Resources for evaluation. They will find that they are not mentally retarded, that they may be a borderline level. Then the defense will hire an expert that will say they are mentally retarded, and you set up the dichotomy. My concern is that a jury is, in a death penalty case, is repeatedly told that they will have three choices: life without parole, and death. When the issue of mental retardation is put to a jury, they don't understand the results because they're not told. They can't be told. Normally, they should not even be concerned with the results of their verdict, only with the truthfulness of their verdict. But here, if they find the defendant guilty but mentally retarded, it stops the issue of life without parole. The death penalty structure of the trial ceases and the defendant is then sentenced to life with parole. The added language that Mr. Martin suggested, I don't think would fix that particular problem because of the Ingram case and others. As Chairman mentioned, there is a bill that's coming that might fix that problem, and I would be much more comfortable with this if that bill were to be passed. But we know how that things that are coming don't always get here.
Okay. Thank you very much, Mr. Floyd. Any questions from members of the committee? Questions from the committee. Representative Bearden.
Thank you, Mr. Chairman. The only issue I have is by lowering this standard. I have a big concern when it comes to victims' rights and the victims, their justice being served out to the victims. In your opinion, by lowering this, could that allow someone that should receive the death penalty not get the death penalty?
Not get the death penalty or life without parole. Whichever, it takes those possibilities away from the jury.
Thank you.
Representative Collins.
Thank you, Don. Do you have any language that you would, I mean, I agree with you. I like this other bill that we've heard of, and I would fully support it. And again, you can't vote on a basket that's not full of eggs yet. Is there a language here that we can ensure that in this bill?
I spent, and others, about a week working on language on the bill, it's Senate Bill 145,
right,
that allows life without parole without having to seek the death penalty. It goes into several statutes. I don't think you can do it on this particular bill. I know you can't do it easily.
Okay. But so I think our emphasis would be to actually, on this other piece, would really push. Okay. All right. Thank you, Mr. Chairman.
Were you through? Okay. All right. Representative Mangum.
Thank you, sir. I think my question was pretty much asked by Representative Collins, but I was trying to follow you on the practical aspect. Basically, as I understand it, there's some legislation that would allow life without parole, and right now there's no middle ground. You're saying for a jury, the jury will either do death, or the three choices they ordinarily have, they're missing that some kind of way. And as one who does not do criminal law, will you help educate me a little bit more about that in light of this other legislation that was out there pending?
Well, set the other legislation aside. In the death penalty case, if the jury finds the defendant guilty of the crime, they have three choices: life with parole, life without parole, and death.
Right.
If the jury, after hearing evidence, finds the defendant guilty but mentally retarded, the trial stops and the defendant is sentenced to life with parole. They do not have that other option of life without parole. That's my biggest concern, frankly.
Okay. So life without parole, that is what this other Senate bill out somewhere that may or may not come, that's your concern that they would, that bill may take care of that issue? Is that?
That would take care of the issue in the sense that the judge would then have the option under that bill to sentence to life with parole or life without parole if that bill were to pass and be signed by the governor.
And is it that in a mentally retarded situation, that's not a situation where, and help me because I'm a little lost here, I do know that there are some mental illnesses that are curable, or you can come back to some reasonable functionality. This is not the situation for those cases where a person could come back to some reasonable functionality versus the ones where they're permanently, quote unquote, I don't know whether that's a scientific terminology, mentally retarded. Those are the cases where they do not have any recovery of functionality of their mental status.
I would be afraid to try to answer that question, Representative Mangrum. My concern is with that class of individual that is not clearly retarded.
Right.
There may be some claim of retardation. There must be a finding. The people that are what you might commonly think of as mentally retarded, there usually isn't a debate about that. There usually is some compromise by both sides when that's clear and an appropriate sentence reached. It's that group of people that there is debate about whether they are mentally retarded. They're not as smart as everybody else. They're referred to on the upper level of that as borderline intelligence, is I believe the technical term. Whether it's curable or not, whether they are trainable or not to get out of that range, I couldn't answer.
And you're basically saying, if you would, Mr. Chairman, if you're basically saying that instead of taking away one of the three alternatives that a jury would have, this takes away all alternatives. Is that basically your position?
Takes away two of the three.
And you would prefer that they only take away one. Is that your position?
Well, my position is that it takes away several choices, and this committee needs to understand the results of what raising or lowering the burden would be, what effect it could have on the death penalty scenario.
Okay, would you be satisfied, however, if there was an opportunity for for the jury to decide? Basically, what I'm asking you, are you saying you want the jury to decide whether or not there should be no parole?
Yes.
Okay.
That's my point. Yes.
And you're basically saying the efforts to include that type of language have not, or has there been an effort to include that language?
About 5 minutes ago.
Okay, 5 minutes ago.
Mr. Martin showed me some, what about this type of situation?
Okay.
And I do know from my work on Senate Bill 145, it's a little more complicated than just adding the words life without parole to this bill. It needs a little more comprehensive rewrite.
Okay. And I am going to try to conclude, Mr. Chairman. I didn't get an answer to the former, I saw a couple of heads shake, but I was wondering whether you were trying to get to the point where a person would recover and they would be no longer considered mentally ill, whether or not that was envisioned in this reason for not having life with or without parole, which I think like Representative Bearden might be concerned about, because is that a concern or is not a concern?
I'm not sure I understand your question. I'm sorry.
Okay. I am aware of certain situations where there is mental illness. I know, and that's what I'm trying to be clear. Well, I know what my question is. Are you concerned that there's a situation where someone will be declared that they're no longer mentally ill? Because mental retardation is something you don't recover from. Is that my understanding?
My answer to that original question was I'm not sure. I don't know.
Okay, I heard yes over there. So that's not an issue that you're concerned with.
I don't know about that.
I know, but I'm just trying to see what your concern is as a prosecutor versus some of these other concerns out here. and that there's a reason why there's a no parole, because no parole means that you're not changing, buddy, so we're going to keep you in the system. So basically, as I understand it, this is a condition called mental retardation, and there's no coming out of that pit once it is down in that hole. Is that your understanding?
I don't know the answer to that question, but to get to your point, my concern is that there are some people that some experts, mental health experts, would call mentally retarded. I might disagree with. My mental health expert might disagree with, who has committed a horrible crime, who is, in plain terms, mean, who is dangerous, who does not need to get out of prison, and to lower the burden and allow a jury to vote guilty but mentally retarded in a death penalty case, take the death penalty out of it, prevents them then from sentencing him to the kind of prison term where that person would be taken out of society and would not be a threat again. That's my concern.
So if I understand you correctly, you really just want to be able for the jury to sentence, to have life without parole as an alternative. Is that correct?
Yes.
Okay. So I now understand, and I don't know what the author's opinion is and what these amendments that you have, but if this is something where a person, that's a policy decision that this body will make, I'm sure. Thank you very much.
Thank you, Representative Mangum. I'm going to try to take these in the order that I saw them flashing. Chairman Cooper.
Okay. What happens, because I'm not a lawyer, if the courts are beginning to overrule these, when, apparently what happens is when it goes to appeal, and apparently my understanding is that when these cases, and they lose and they think somebody's mentally retarded, then they appeal it, and that the appeal court is ruling on, what we're trying to do here. They're lowering the standing on the appeal case. What happens? Are those people retried again, or what's happening? And what happens if we don't comply? If they're throwing all these cases out because they're unconstitutional, whatever? What happens to us if we keep this higher standard?
I disagree with the premise of your question. The Georgia Supreme Court has upheld this standard. Now, there may or may not be concern. It depends on probably who you talk to about what the Supreme Court of the United States might do next year or 5 years or 10 years down the road. We don't even know who will be on the court. That is a common concern and subject of discussion when talking about things like this. There is no, that I'm aware of, any court that it is imminent that they're going to find this burden improper or unconstitutional. The Georgia Supreme Court has upheld the burden.
Okay.
And I called Fred Bright, the DA in Milledgeville, the Okmulgee Circuit. Mr. Martin brought his case up in his situation. And I asked him why he did that. He did, in fact, just simply agree, not argue with letting the judge charge on the lesser burden. And he said, because I just didn't care. It didn't matter to me. It wasn't a statement on what he thought one way or the other. So don't misunderstand that there's some case out there that this is somehow imminent that it's going to be resolved, because I'm not aware of it.
Okay, because that's sort of, unless I'm just totally misunderstanding what's been presenting, that's what has been presented to us. Okay.
Okay, Representative Setzler.
Thank you, Mr. Chairman. I'll try to keep it brief. It seems to me that if the standard to prove someone's is being mentally retarded and thus not subject to the death penalty is here, and if you set the bar here, given there's enough folks in trials that try to reach that standard to prove it, to take death penalty off the table, it would seem if we lower the bar that we're going to invite even more and more cases that wouldn't normally go after this contention. It would seem that in more and more cases that the defense would contend this, And it would seem to be that we'd be inviting, since there's not a requirement to demonstrate beyond a reasonable doubt, which is a very high standard, which would, with all the evidence that's brought to bear, would seem to need one or two just compelling pieces of evidence. It would seem that because all you need to do is tip the balance, this would seem to bring about circumstances in which just a whole host of things would be brought to bear to try to prove the overall balance the person's retarded. Is that really what we're inviting by doing this?
I think so, and I think that the argument that it doesn't matter the standard, and I've heard this said, Mr. Martin didn't say this, but I have heard it argued that, well, juries don't pay attention to this anyway. But they do, because the good lawyers like Jack Martin stand up there and argue and demonstrate very clearly just what you did. Preponderance of the evidence means just a little more on the scales, while beyond a reasonable doubt is a much higher burden. And so I do think it matters, and I think there could be some dangerous people in a position where they could be paroled at some point in time if it's lowered. That concerns me.
Sure. Representative Abdul Salam.
Thank you, Mr. Chairman. Thank you, Mr. Floyd, for your thoughts and your comments. Clarification, first of all, did you say at the beginning that you were representing the Council of Prosecuting Attorneys?
No, the District Attorneys Association.
District Attorneys Association. Okay, I wanted to make sure. And I guess looking at the legislation, and again, not being that familiar with criminal law, it seems to me that the only thing in question or that's being done with this legislation is adding 10 words. And those 10 words only speak to mentally retarded. So are we being somewhat, I guess, confusing when we talk about mental illness and all of the other possibilities? We're only dealing with mental retardation.
That's the only thing this bill
does. That's the only thing this bill does.
Mentally retarded.
That's the only thing. It won't affect any other existing law as is.
As I read it, it doesn't.
It does not. Good. I'm with you on that one. Okay. And I guess my second part of that question then would be, isn't the mental competency issue answered at the beginning or even before trial starts? It's not something that would wait until sentencing?
Competency to stand trial is handled in a civil trial as a prerequisite to the criminal trial. One must be found competent to stand trial, which is a mental health issue, or you could be incompetent because you're retarded.
That's what I'm asking.
Incompetency to stand trial could encompass severely mental illness that would prevent you from understanding the nature of the trial and so forth, or you could be so severely mentally retarded that you would not understand the process of trial and the consequences and so forth.
So if at the beginning or prior to the trial starting, there is a ruling that the defendant is incompetent based on severe mental retardation maybe, then would that change the sentencing options?
If a person is found guilty, if a person is found incompetent to stand trial, they don't stand trial at all.
Okay.
They have to go into the custody of the Department of Human Resources, who goes through a particular program and then reports back to the court.
Okay.
You don't reach the trial.
So you won't have to worry about that.
Well, you just don't reach it.
Okay. All right. Thank you.
Thank you, Representative. Is that you flashing again, or did I not turn you off last time, Representative Mangum? Okay. Further questions from Mr. Floyd? I'm not sure what this means, Representative Mangum. Your light will not go out. I'm going to leave it up to the committee. What's the vote? No, I've never cut a committee member off from asking a question. If you want to ask a question.
Floyd, with the procedure that the judge holds before the trial,
yes.
Has there been any thought by yourself or members of your association about having a this determination prior to the trial so that the jury, it is not a, it's a set like a bifurcated matter that whether or not they're mentally retarded is actually decided separate and apart from whether or not they are guilty of the crime?
I'm not aware that we've considered that. I have not been involved in any consideration of that.
Would you be opposed to such a scenario?
Probably.
Why would you be opposed to it?
Well, you have that already in the incompetent stand trial, the special plea of insanity situation. To set that out, and you're catching me cold here without having thought about it. Those are usually jury questions, whether a defendant is not guilty by reason of insanity, where a person is guilty but mentally ill, or whether a person is guilty but mentally retarded, have all been traditional jury questions. Even the issue of mental incompetency to stand trial is a jury question. It's simply a civil trial put to a jury. It's not put to a judge.
Right. I understand that from your previous testimony with Representative Abdul Salam. I guess what I'm trying to get to is try to accommodate your concern that if a person is not clouded with the issue of whether somebody is mentally retarded, it's already been determined, then you can then have the trial and have your three options that you were concerned with, or your two options rather, because you're not concerned with whether or not, if they're mentally retarded, just take one off the table rather than take two off the table.
Well, there's some potential there's some legislation out there that would allay my concern.
And that, but you would be okay if we just took one off the table rather than two off the table.
I think so. I'm not real sure.
All right, thank you.
About your question.
Thank you, Representative Mangum. Still can't get your light to go out. I think it's just the magnetism.
This is not easily quelled.
That's exactly right. Speaking of which, Chair recognizes Representative Levitas.
This will shock you, Mr. Chairman. I waive.
I hope we can tape that and keep it. All right. Any further questions from the committee for Mr. Floyd? Any further questions? Thank you, Mr. Floyd, for being with us and helping us through this issue. That was the final speaker that had signed up to be heard on the bill. Any questions from members of the committee of the author? Final chance to question the author. Okay. What's the pleasure of the committee? I'm sorry, Representative Randall don't want to be recognized. Okay. What's the pleasure of the committee? Representative Mangum.
Could I ask the author of the legislation whether or not he has any legislation that would assist the previous testifying witness concern about taking one versus two of the options away from the jury?
I don't have an objection to adding that amendment, but he said himself that he doesn't see how to do that and doesn't think that the fix that's been proposed would be adequate. So, while I have no objection to adding the language Mr. Martin suggested, I'm not sure it would satisfy the gentleman.
That's one question I did not ask him, but I would think that it doesn't satisfy him. Doesn't?
I thought I answered that. No, it does not.
Okay.
I don't think it fixes the problem.
Okay.
That's the reason I haven't offered that as an amendment, because he says he wouldn't be satisfied even with that.
Thank you.
Representative Abdul Salam. You're recognized. We have a motion. Do we have a second? We have a motion and a second now. We're ready for discussion on the motion. Representative Levitas.
I have a substitute motion.
State your motion.
Motion to table.
Is there a second? All right, we have a motion to table House Bill 1298. I don't think that's subject to debate, is it? Or is it not? No? Okay. All right. We will take up the motion, the substitute motion, at this time. Representative Bearden, you have a parliamentary inquiry?
No, sir. It's about to be discussion, but since we made a motion to table, I'll just stick my.
Okay. All right. The vote will be to table House Bill 1298. All in favor of the motion to table will vote aye by raising your hands at this time. All right. Did you get them? All opposed, raise your right hands. House Bill 1298 has been laid on the table. Okay. We have two other matters on the agenda. Are you working your way back this way, Vice Chairman? Okay. $11.79.
Call House Bill 1179. Call on the chairman to explain his bill.
Thank you, Mr. Chairman and members of the committee. Given the late hour and the fact that we still have one more bill, I will be very brief. This is a very, very simple bill that simply requires that registered lobbyists not be convicted felons or have at least had 10 years passed since the removal of their felony status. It's simply designed to bring a little higher standard to that group here at the Capitol and other places. I think it's a good government bill, very simple. There was some discussion earlier with Sandy Michael and Jack Martin about some language that would, I guess, Jill, I may want to visit with you on later about, do you need to put if they've been exonerated or a conviction has been vacated or reversed, and my thought would be that the current law would take care of that, but if I've told them I will have that discussion as we go forward. With that, Mr. Chairman, I'll be happy to answer any questions.
Are there any questions for the chairman? Mr. Bearden? Mr. Setzler.
Thank you, Mr. Chairman. To the author, did you consider maybe a total prohibition that after 10 years someone perhaps ought still not be able to lobby? Is that part of the discussion? I mean, I'm sure you spent plenty of time thinking through this.
I have spent much time thinking about this, and I thought about a total prohibition, to be candid with you. I think, though, that in balancing the right of a person to engage in trade and work against that, I thought that the 10 years was a fair balance.
And Mr. Chair, my only concern is, this isn't just somebody that's earning a living for their family. It's somebody that's actively engaged in the process of government and making and influencing public policy. My only concern was the 10-year piece. There seemed to be other. In fact, I don't even know what the standard is in serving the General Assembly. I don't know if you could have been a prior felon and serve the General Assembly. But that's just a concern of mine, Mr. Chairman.
I think this is if I may, Mr. Chairman.
Yes.
This profession now has no standards. It has no code of ethics. It has no ethical guidelines. And I'm not sure I disagree with you, but I also think this is a good start. And as we go forward, this may be a good point from which to build as we move forward.
All right, Mr. Bearden.
Based on the same lines, I just going to see whether the sheriff is married to the idea of 10 or 20 be I'd just like to see a little bit higher area, but if that's something that you came up with and you're comfortable with, then I support that.
I would not have strong opposition to raising it. I mean, I think 10 is adequate, but you know, if it's the will of the committee to strengthen it and make it 20, then I don't have a real objection to that.
Abdul Salam, is that your, wasn't you? Is it you, Nikki?
Thank you, Mr. Chairman. I'm just kind of wondering what brought on this legislation. Is there someone in the halls that I should be aware of?
We're going to find out. And yeah, the answer is there's plenty out there that you should be aware of.
Thank you, Mr. Chairman.
Mr. Everson.
Question, Mr. Chairman. I noticed on line 14, it addresses an individual that has been convicted of a felony in this state. What about other states? Did I miss something?
Jill, is there a way we can deal with that?
Where?
Excuse me? Yeah, would have been, yeah.
Oh, I missed that.
Okay.
Thank you.
All right, are there any other questions from members of the committee? Abdul Salam.
I guess I would ask Chairman Ralston, he'd be the best person to know, what kind of feedback have you received from the lobbyists?
They have, that community has been fairly supportive of this. I think they understand the need to have a little higher standard, raising the culture on the other side of the rope. And so I think I haven't had anyone come and express serious reservations to me personally about the bill.
Okay. Thank you.
Any other questions? All right, I don't see any other questions. I'd like to know the will of the committee in this matter.
I have a motion, Mr.
Ms.
Chairman.
Randall. Is this a question or a motion? No, this is a motion. All right, well, Mr. Levitas had previously requested that. Mr. Levitas,
Could I prefer Representative Randall?
I would be happy to withdraw my motion. I think you'll like it, though, Mr. Chairman.
I wouldn't want to deprive Mr. Levitas of his moment in the sun.
You're the chair.
Very, very few of them. I appreciate that, Chairman Mumford. Mr. Chairman Mumford, I do move that this committee do pass House Bill 1179.
Is there a second, Ms. Randall?
I second the motion.
A second. All right, is there any further discussion? Seeing no further discussion, all those in favor say aye.
Aye.
Those opposed? Passes.
Thank you, Mr. Chairman, members of the committee. We have one item of business. At the beginning of the meeting, there was a request to add a bill that was heard in subcommittee earlier today, and I asked the members of the committee if there was any objection, and hearing none, we have added to the agenda Senate Bill 276. To begin the discussion on that, I'm going to recognize Chairman Knox, who is, I think, going to handle that on the House side, whichever. It might be better over there. We can all see you.
That'll be a treat, I'm sure, for all the members. Chairman, I think we changed our mind about adding this.
Well, we blew through the others fairly quickly, so today may be as good a day as any, Representative Randall. Chairman Knox tells me that it won't take long.
It only hurts for a little while, Mr. Chairman.
It'll only hurt for a little while. Chairman Knox.
Thank you, Mr. Chairman. Mr. Chairman.
Let's give the gentleman some attention, please.
Mr. Chairman, members of the committee, thank you. This is Senate Bill 276. It was brought to us last year by Senator Staten, and he's asked me to help him with this bill. As you may recall, this originally came to us as an issue over uninsured motorists, and a couple of things brought that to the fore. One of them was a court case involving umbrella policies that were under Abrams versus Atlantic Mutual Insurance Company, in which the appeals court found that a umbrella policy could be used as required to cover uninsured motorist coverages, which had not been prior to that time thought to be the case. In addition to that, we had a case called Dees versus Logan, which allowed addressed the issue about offsets for workers' compensation and medical payments coverage, in effect allowing a person that had an injury in an accident to collect twice on that injury for those amounts of coverage. In addition to that, we had, I guess it was a year before, maybe 2 years before, we had before us an issue about open rating for insurance policies, or it's commonly understood to be in the industry and in insurance parlance, file and use policies. And so, in order to try to address that issue, we had several and a number of insurance issues, including that one. We had several hearings this past summer to try to see what we could do to remedy some of the issues that were brought up by both this bill and by some problems having been brought to us by way of the appeals court. And the way we've done that is we have listened to consumers and consumer advocacy groups who have said that their interest in the uninsured motorist bill was that there should be consumer options in the uninsured motorist coverage, and so we've addressed that in this bill by basically requiring companies to offer 3 different levels of uninsured motorist coverage, one of them being an option that would allow what has been referred to as stacking of uninsured motorist coverage on top of other liability coverage, and secondly, to continue with the current law, which is the uninsured motorist that is currently available and selected typically by the insured. And then finally, the ability of the consumer to reject uninsured motorist coverage altogether if they don't think that they need it or want it. And then, of course, we have the issue of the availability of coverages under the open rating or the file and use plan of insurance, wherein an insurance company is able to offer coverages without prior approval of the rates. And so we had a number of hearings on those, and one of my concerns about the plan for the open rating policy was that we have in Georgia required persons to have coverage in a minimum mandatory amount. And in light of that fact, it seemed to me that it was not appropriate simply to allow companies to price those policies when the state has placed the obligation to have insurance on the driver of a vehicle because the driver operates under a license from the state of Georgia. And so we should not abandon our responsibilities in attempting to control and monitor the rates on those amounts of insurance that persons are required to have by the state. However, that doesn't mean that we shouldn't allow persons to buy additional coverages over and above those amounts when they think that they need to have additional coverages and when they have assets that they would like to protect that are over and above what might be protected by the minimum mandatory coverages. It's interesting to me that during the hearings that we had on one of the bills with regard to the rating issue, we had some professors from Georgia State University School of Insurance who came and testified about the favorable outcomes from having open rating policies around the country, and that it allows consumers to have more choices at lower cost, almost invariably where they have looked at the states that have those kinds of laws. That being the case, and also I think we've heard from Clark Howard, a well-known consumer advocate, that he thinks that it's appropriate to have open rating plans in most instances. My concern with that, and I agree with that, except to the extent that the state requires us to have insurance on an automobile in order to be able to operate an automobile. And so in this bill, we have 2 tracks. One is for those amounts up to the minimum mandatory amount, which is the current law, and that the insurance commissioner will continue to regulate the rates of those premiums. And then we have another track that provides for coverages that are over and above those minimum mandatory amounts, and those would not be regulated by the commissioner, but rather would be under the scheme of file and use, or competitive rating, as some folks call it. And essentially, that's what this bill does. I can say without fear of contradiction, I think that almost no one who has an interest in this likes everything about this policy. I've heard from everybody, I think, about something that they don't like about this policy, about this bill, rather. Probably the one who's most adamant about it is the commissioner, and I think his primary concern is about not rating about allowing the open rating portion of the program. That's basically the bill.
Thank you, Chairman Knox. And let me just ask a question or two. Is it not true that you have led an effort over a number of weeks now to bring all of those who have an interest in this issue together and try to forge as good a compromise as is possible?
It's longer than weeks, Mr. Chairman. I think
months.
It goes back a lot.
Or the last year.
Yes, sir. And that's correct. I think I've talked to everybody that has expressed an interest in it, or that I thought might have an interest in it, in order to make a bill I think that would if not wouldn't be accepted by everybody, at least that everybody would be able to think that they had that it was something they could live with.
And is it not true that that the bill that we have before us, although maybe not agreed to by all, certainly another individual who had a hand in this was the Speaker, and he's been active in trying to produce a moderate, good resolution of all of the competing interest here.
That's correct, and I've tried to keep the Speaker apprised of what I've been doing, as I have with other folks who were involved in it. Letting them know how I was proceeding and what I thought the direction was that we needed to take with it, and so certainly I did address that with him also.
All right, Representative Bearden.
I'd just like to say congratulations, Chairman Knox, for keeping up his record on making everybody mad on a piece of legislation. So, doing good work on this.
Thank you very much.
I'm sorry. That's it for today. Any questions from the committee members of Chairman Knox?
I should point out that it passed with a due pass from the subcommittee. I think unanimous, if I'm not mistaken.
Okay. Yeah, we didn't ask for sign up. Well, I do this with fear and trepidation. Is there anyone who feels the need to add to what was said in subcommittee? And we'll try to do that in an orderly fashion. And I see the commissioner's agent. And
very quickly.
Sure.
I've tortured members of the subcommittee long enough earlier today, including my friend the chairman. It's not enjoyable for me to talk against Chairman of Insurance's bill 2 times in one day. Just briefly, our concern, as the chairman reflected, is the changes to the prior approval rating requirements for private passenger insurance. And we understand the chairman's vision of 2 tracks, one that would be prior approval for the mandatory minimum liability requirements that Georgia requires drivers to obtain to lawfully drive on our roads, and that if they chose higher limits, that they would not be subject to those prior approval requirements. And I wanted to correct maybe one misimpression I left earlier today in the subcommittee, and that is I do believe, as written, that if a carrier increased the minimum liability limits by 1 cent, then they could remove themselves from the prior approval requirement. But it's not just a dollar amount by which this is done. The way the bill is drafted currently, if it is, let me refer to the page briefly, Mr. Chairman. For private passenger motor vehicle insurance providing only the mandatory minimum limits,
That means that the only thing that that policy contains is the minimum liability requirements. I think ironically, since this bill originated as an uninsured motorist bill, if someone has selected the minimum liability requirements plus uninsured motorist, they are going to be automatically outside the prior approval requirements. And we probably think that 80 to 90% will be outside those requirements as soon as the bill is enacted into law. And I just wanted to make that clear. Appreciate it.
Thank you, Mr. Jackson. Anyone else? Yes, ma'am.
Mr. Chairman, my name is Allie Wall. I'm with Consumer Watchdog Georgia Watch. We presented testimony and a series of suggested improvements to Senate Bill 276, and Chairman Mumford asked us to present language to that effect. We've done so, and at this time, we've submitted our suggestions, and it's really the will of the committee.
Okay, thank you very much. So you're not happy either? Along
actually, no. We commend the substance of the bill. We think it's a great first step. You can improve on anything.
Sure.
We have a series of suggested improvements, but I wouldn't characterize us as being unhappy. In fact, I'd say that we're in support of the bill.
Okay. Representative Collins, did you have a question or
Yes, sir.
a comment? Okay.
I had a question. It was for the insurance commissioner's office. And I do this with much fear because, out of respect to the chairman, I have no desire to sit on the insurance committee. I like where I'm at right here with this committee. But you keep bringing up this out of the 1 penny over. What was the statement that it brings it out of what?
Well,
prior approval.
Right.
Explain what that means in English that I can understand, which is very slow North Georgia English. Okay.
I grew up in Mississippi, Representative, so you don't need to qualify your ability to understand. Prior approval, currently under current law, private passenger auto rates must obtain the carrier files and must obtain the department's approval before they can use that rate. And so the two tracks that the chairman envisions are for the minimum liability requirements that are compulsory in the state of Georgia, that if that's what you're selecting, and as the bill reads, if that's the only thing that you're selecting, that product would still be subject to prior approval. If there was a change in rate, then we would have to approve that before the carrier could implement that rate in the marketplace. Everything else besides minimum liability requirements would be subject to file and use, where they file it and they immediately can begin using it in the marketplace, and we don't our prior approval is not required. That ticket doesn't have to be changed.
Chairman Knox, Mr. Chairman, can I just Chairman Knox, is that your understanding of?
No, and I don't really want to debate it, but my response is that no one's required to have uninsured motorists today in Georgia, and they won't be after this bill is passed. This will simply be if you want it, you can get it, and there's 3 different options that you can exercise in order to have it. But the thing you are required to have is the minimum mandatory liability coverages under Georgia law. And what I'm saying, and believe me, a lot of people don't agree with me on this, but I think if we require somebody to have that insurance enforced, then we ought to stay involved in the process and have some control over the rates that are charged for what we require people to carry, period. Now, other than that, if you want to get coverages other than that to protect assets that you think you have that are in excess of that minimum mandatory coverage, and you want to have it and you think you need it, you can go get it. You can do that today, except that you can't get it at the rate you want to get it. You have to get it at the rate that's set. Now, and we're talking about insurance that we didn't say you have to have. That's just insurance that you can buy if you want to. So I don't think we should be in the middle of people making contracts for their business as a government. I think that ought to be up to them.
I agree. Thank you, Mr. Chairman.
Thank you, Representative Collins. Any further questions from members of the committee? Any further questions? Anyone else care to be heard? Anybody else want to be heard? This is the sign-up sheet. Oh, I thought you were trying to recruit speakers. That's a first. Did Vice Chairman Mumford want to vote? Okay.
Well, I think they said they were okay with the bill. I think they have some ideas about some language. I'd be willing to consider those, but that's something we could probably take care of after the committee.
Okay. Any further questions? What's the pleasure of the committee? Representative Levitas. Have a second? All right, we have a motion that Senate Bill 276 be given a due pass recommendation. Is Vice Chairman Mumford wish to be heard? We should have done this earlier. Sally, would you find out? Tell him I need him, please. If I understand your position, Chairman Knox, you would resist any amendments today. Is that correct?
Yes, we've spent a lot of time getting the parties together, and I think I've tried to address the issues of everybody, including the consumers groups. And
okay.
I'm pretty satisfied with the way it is.
All right, we have a motion to give this bill a due pass recommendation. Is there discussion on the motion? Is there discussion? Hearing none, all in favor of the motion, please indicate by raising your right hand. All opposed? All right, we will send that one on to the Rules Committee with a favorable recommendation. Thank you, Chairman Knox. Let me, we're going to be a little scheduling issue here. The Mumford Subcommittee is meeting when?
It's meeting at 9 o'clock in this room, but initially Mr. Bearden has agreed to chair that because I have to be in the rules at that time.
Okay. Mumford Subcommittee meets tomorrow morning at 9 a.m. here in room 132. We will be meeting again later in the week, and I'm not sure at this point whether that will be Wednesday or Thursday. We're going to be governed to a large degree by the rules calendar for Wednesday, if there is one, and but we will have another full committee meeting, and I'm hoping the Knox subcommittee may have an opportunity to meet before that. Representative Bearden? Oh, I'm sorry. You want to make that announcement? Chair recognizes Representative Bearden.
Just going to say, everyone on my subcommittee, hang on for a little while. We got 3 bills to take up. Hopefully they won't take too long, except for Levitas' bill.
Can we take about a 5-10 minute break?
Yeah.
Well, this meeting is adjourned.